for delivery of order of Janagar Bank. Item 1, WPC 47 of 2022.
Petition allowed. Cost of rupees 20,000 imposed upon respondent number 3 and 4.
Yes, mentioned.
Yes.
My lord, I beg to mention, my lord, on AB, my lord, unlisted at 2 p.m. today, my lord. I am a president of the Gosala of Mahal Bay, my lord. 30 cows have been missing from the Gosala, my lord, since police is searching me, my lord, for last 3 days, my lord. So I am mentioning this matter at 2 p.m., my lord.
Today?
Today, my lord. Please agent, my lord.
No, today not possible. Not possible. We have already 56 matters. Today, on Monday.
Monday then, my
May I please, Your Lordship?
Yes.
Lordship, beg to mention matter for listing for Monday, my lord. It's a PA. The person is 70 years old and behind bars. He has been granted bail in another matter, but it's shown arrest behind bars only and taken into custody again.
Monday, okay.
Monday.
May I please, Your Lordship? I recommend item 32 minutes. In this matter, my lord, we are in interim. It is number 3. My lord, the casualty has not been received.
Mr. D. Bora, learned counsel for the applicant, submits that the matter may be taken up on. When?
No, my lord. After beautification, 32. Item number 32. 32, my lord, here. Search sheet submitted, my lord.
Search sheet submitted.
My lord.
When?
Honorable put test for trial and file search sheet number 31/10/23.
Under section?
My lord, that is not reflected in our my lord, report, my lord. Only search sheet number and date.
No, whether search sheet is submitted against the present applicant?
My lord, I will confirm, my lord. At 2, my lord.
Okay. 2 p.m.
My lord, I beg to mention item number 55 of today's list, my lord, supplementary list, my lord, on behalf of Mr. S.P. Chaudhary, my lord, senior counsel.
55.
Yes, my lord, he is not well, my lord. This matter may come up after 2 weeks, my lord.
You are for the
Here, my lord, in the IA for the opposite party, my lord, in the petition, original petition, and for the petitioner.
on the pair being made by Miss
S.B. Chaudhary.
learned counsel for the learned counsel appearing on behalf of Mr. S.P. Roy. Learned counsel for the petitioner. List the matter after
Weeks, my lord.
2 weeks.
And the interim may continue, my lord. There was an interim in the main case.
Till next that interim order passed earlier shall continue. Yes.
My lord, I have filed one criminal revision petition, my lord. It may come up on Monday, my lord.
Monday may not be possible.
And there will be
Is there any urgency?
urgency is there, my lord.
What
because
urgency?
It is against an interim order, my lord. So regarding maintenance, my lord.
Okay, on Tuesday, Kabir?
On 9.
Yeah, resolution, my lord. I beg to mention item 19, my lord. 439 is, my lord. May I pray on Monday, my lord? On the,
Why?
my lord, I have to leave the court for some personal difficulties. Only Monday. CD is available. CD is available. Monday, my lord, I have 439 minutes.
No. Why on Monday? Why not today?
My lord, my personal, I have to leave the court, my lord.
No, anyway, we will consider the bail petition on the basis of materials available on the case diary.
Then second half, my lord, may.
Second half, yes, second half.
My
lord. Item number 31, my lord. Probably my CD is not available, ma'am. I am in interim, my lord.
No, CD not.
CD
Not received.
31.
Yes, my lord.
On the pair being met by Mr. S. Barthakur, learned counsel for the applicant, list the matter on when
Common matter is, my lord. 22nd, my lord.
22nd.
My lord.
On that day, learned additional PP shall produce the case before this court.
My lord.
An interim order passed earlier shall continue till
Right.
then.
May I please your lordship? Lordship, I am praying for listing of a criminal appeal, my lord, any day of next week. my lord.
Okay.
Also,
You choose the date and
46.
Okay, after vacation,
My lord, before vacation, my lord.
before vacation.
on 11.
May I please your lordship, item number 46, lordship. Pass over for jail, criminal appeal.
46.
46.
Yes.
Pass over for jail.
Why?
Today I is not ready, lordship, actually. I am come from the village, lordship.
You inform the other side?
The inform, other side is not appear, lordship, sir.
No.
Instead is
Who will call the matter? Next.
Next,
May it please your lordship. Lordship, I beg to mention to criminal petitions, my lord. My lord, anytime after the vacation, my lord, I have stay also so for other side has appeared. And my lord, another prayer with regard to a criminal appeal which was last listed for hearing in July, my lord. Subsequently, my lord, I had mentioned also, I have applied for the registry also, my lord. So that was given 3 weeks in the month of July on 27. Anytime after the vacation, lordship may allow. Deeply obliged.
may I please your lordship? May I please your lordship? No, I prefer listing of a criminal appeal, my lord. There is a I for bail, my lord. On next week, my lord. I have this.
May I please, your lordship? Lordship, I beg to mention an item for withdrawal on Monday, lordship. Criminal revision petition. Obliged, lordship.
May I please your lordship. Lordship, I beg to mention BA number 18 to list the item today, lordship. BA number 18/24, lordship. Urgent matter, lordship. May be taken up today
Today we have lot of matters.
or
May not be
taken up
possible.
on 9th, lordship. 9th of January.
On 10th,
10th. Obliged.
May I please, lordship? I beg to mention item number 27, lordship. Is that is not available, lordship?
My lord, it is just received, my lord. 26 and 27, we have just received.
Okay.
Can you
Second
please
half.
present
Second half.
second half?
Lord, I beg to mention for unlisted matter, lord. Petitioner advocate is behind bar since 1 month, lordship.
Today may not be possible. On Monday.
Obliged.
may I please your lordship? Lordship, I am praying for listing of a criminal appeal any date after vacation. 25.
May I please, your lordship? Lord, I am praying for listing of IA in
When?
criminal in criminal appeal, my lord.
When?
After before vacation.
23.
May I please, lordship? For item number 12, my lord, 1, 2. Item number 12, kindly matter may be withdraw, my lord.
Matter may be?
Withdraw. Withdraw this matter.
Item number 12.
12. For withdraw.
This is for admission.
Zimma matter, my lord.
Admission.
Criminal petition. Zimma matter.
No, the matter is listed in the admission column.
Petition format.
You want to withdraw this petition?
Yes.
Your good name?
Al Islam.
Ms. So-and-so, learned counsel for the, your name is not here?
Not here.
On behalf of S.
Appearing
Sunil.
on behalf of Mr. S. Monir, learned counsel for the petitioner, submits that she has the instruction to withdraw this application. Here is accordingly allowed. This criminal petition stands disposed of on withdrawal.
I do.
My lord, I beg to mention the for listing of the case criminal petition, my lord, it is pending for last 2 years. CD is not given, my lord, now 2 years, my lord, 8 or 9 occasion. Last occasion also CD not given from Hosai. So maybe listed, my lord, this time.
When?
My lord, next week if possible.
After vacation.
Next week may not be possible after vacation.
Yes, my lord.
23rd.
Immediately after reopening. When?
On 23rd.
Sorry.
On 18th.
18th. Obliged.
Please, your lordship, I beg to mention for listing of a criminal appeal for hearing.
When?
Already petition, before you,
Before,
11,
beyond,
12,
not
no.
possible, after beyond,
25.
23, maybe.
23.
23.
Okay.
Is it
23.
hearing day, Kobe?
Yes, Lordship. Yes,
Okay.
Lord. On hearing.
Okay, okay.
Please, your lordship.
I pray for listing of an IA for suspension of sentence, my lord.
When?
Any day. After vacation also.
24.
Hello. Please, your lordship. We pray for listing of an IA, my lord. This is regarding interim compensation. This was supposed to come up after puja vacation. It has not been listed. So, my lord, any day after vacation.
22nd.
22nd. Deeply.
Lordship, I beg to mention item number 13 and 43. Kindly, the matter may be fixed after 22 of Jan, as senior is out of station.
13 and
30 we have
13 and 43.
13 and
43.
What is it? That is orders. 30, sir. 30.
1, 13.
Oh, 30, no, 30.
your good name, please.
Miss P. Bora. 13 and
Ms.
43.
P. Bora, Learned Counsel, for the petitioner submits that her senior, who is your senior?
Mr.
Mr.
P.
P.J. Soikia.
Your
He's-
lordship, kindly both the matters may be tagged together.
He is out of station.
He is out of station.
He
Your
is
lordship.
out of station. And therefore praise for listing the matter after
After 22 of January.
29.
29.
29, there is another matter, bail application.
25.
25. Same order in 43 also. Okay.
Right.
Item for withdrawal. Item number 47.
I want to do it.
Your good name?
Aryam.
I.
Aryam.
Your name is not in the cause list.
Here, man. 1, 2, 3, my lord. Are Ahmed.
Manish.
Third number. Are Ahmed.
Acha, R.A. Ahmed. Mr. R.A. Ahmed, Learned Counsel for the accused submits that he has the instruction to withdraw this petition. Here is accordingly allowed. This bail application stands a dispose of on withdrawal.
For motion bail application item 48.
Please, lordship. Lordship, matter may be passed over for 10. Senior counsel is on next.
49.
Correct.
That lordship.
Okay.
49.
And lordship. Lordship, application 439 lordship. The allegation 366 lordship. So whatever lordship, the behind the part since last 23 days lordship.
20?
23 days lordship.
20.
So it's a love and affection lordship. The Facebook interaction in between the victim girl and the petitioner lordship in the month of April 2023 lordship.
Victim was recovered.
Recovered 10-12 lordship.
12.
10-12-2023 lordship. After 2 days lordship. Already recovered lordship.
Let us CD
My
and the
lord, CD,
statement of
my
the
lord.
victim girl.
This could be a course.
This for
Shortcut can be.
CD along with the statement of the victim girl recorded under section 164 CPC on Sharma.
My lord,
Shortcut.
after reopening on 18th, my lord.
18.
18th, my lord.
Yes, sir. Must have.
Item number 1 for motion.
There was a wrongly accused. The timing considered 40th term on the between 1 minute. Okay, 4 quarters is going
Your lordship, I made a mention.
You are not in 48. Okay.
I can.
None appears for the accused on call. List the matter. Data the BA to 19.
19. Item 1.
Item one. So maybe pass over for time.
Item 2.
May I please, your lordship? 438 application, lordship. Lordship, FIR is on page 10, lordship. FIR was registered on 29/11/2022, lordship. CD, man. Lordship, informant is the brother of victim, and victim and accused and victim are both husband and wife, lordship. Lordship, FIR dates way back, lordship, and now they are living together, lordship. Now both the victim and the accused are living together. That is why my statement may be recorded, interim protection may be granted for that purpose. As the victim.
We'll see the case diary
My-
and
my-
the injury report of
Along
the
with the
victim.
medical report, my lord. Interim may be granted as the victim and the accused are living together now. It was a family.
It's all right, we'll see.
My lord. Okay.
If the victim is,
My lord,
in her
statement
statement stated that, she is living with the accused, then okay, all right.
My lord. 19th, my lord. Present status.
19.
19th, my lord.
Case diary and injury report of the
Medical
victim.
report. Obliged.
Item 3.
Wait, please, your lordship. This is the second bail application, lordship. Earlier, your lordship has rejected by the order set 16/10 to the next page 59, lordship. Page 68 is the page 69 is the eligible portion. Here, lordship, the
So
basic-
what is the ground for filing
My
the second
new
application?
Basically, lordship, the earlier the bail petition was written on the ground that the petitioner, after receiving the entire amount, had failed to transfer the vehicle to the informant, lordship.
Mm.
There, in this case, the vehicle in question is under hypothecation to the SBI, State Bank of India, lordship, and there was a agreement in the year in August 2019 where the informant undertakes that he would pay the entire amount of installment within a certain period at a
No, I'm asking you, what is the ground?
New ground, my lord.
new ground, lordship, some materials which with regards to the transaction between the informant and the petitioner failed to bring into the notice of this honorable court. I have annexed the bank statement of in the loan account as well as the saving bank account of the petitioner, in which the informant has paid the installment amount, lordship, and he claiming that the petitioner, after receiving the amount, did not deliver the transfer of
Okay, Mr. Sharma,
My lord.
let the city come.
My lord.
City on, who is that?
My lord, after 19th, my lord. 19th, my lord.
19.
My lord.
Okay. City.
Obliged.
Item 4.
May I please proceed? 438 verification. So can you shift FIR Barnacle at page 11? Mary,
Yes.
সন্মানপূর্বক নিবেদন এই যে যোৱাকালি ৰাতি প্ৰায় 10 মান বজাত মোৰ দেওৰ শ্ৰী বিতুপন বৈশ্যই ভাত খাই ৰাস্তাত ওলাই যোৱা অৱস্থাত মোৰ মাৰ ঘৰৰ সন্মুখত পদকীয়া গুণে মোৰ দেওৰক ধৰি চুৰিৰে হানি থকা অৱস্থাত মোৰ স্বামী শ্ৰী হীৰকজ্যোতি বৈশ্যই দেখা পাই বচাব যাওঁতে মোৰ স্বামীকো চুৰিৰে মুখত হানি ইটাৰে কুকুৰ পিঠিত মাৰে। মই দেখি বচাব যাওঁতে মোকো ঠেলা মাৰি পেলাই দিয়ে। মই ভয়তে চিঞৰ বাখৰ কৰাত স্থানীয় বাসিন্দাৰ তৎপৰতাত দুয়োজনৰে প্ৰথমে প্ৰাণ ৰক্ষা
পৰে। ইয়াৰ কিছুদিন আগত মৃন্ময় বৈশ্যক নিচাযুক্ত কেন্দ্ৰৰ পৰা আনিছে। মৃন্ময় বৈশ্যই ইয়াৰ আগতেও গাঁওখনত মাজে মাজে বহু অশান্তিৰ সৃষ্টি কৰি আহিছে। Lordship, in this case, primary question, so minimal question. Here in this case, there are 4 accused. I am on behalf of 2 accused, Rajeshwar Boisya and Usha Boisya. And Lordship, Minimal Boisya was a primary accused and he was arrested on 12/12/2023.
So allegations are against all the accused.
My lord, all the accused, my lord. সন্মুখত পদু কিয় গণ?
I am the
All the accused.
father and mother of the primary accused.
Who? Rajeshwar Boisya
Yes,
is the father.
father and Usha Boisya is the mother of the primary accused, Mrinma Boisya. Add this is in protection maybe.
Okay, we'll fix a sorted.
My lord,
Let the city come
my lord.
Similar
from
matter-
Hazo.
Hazu Lordship. Lordship, similar matter already fixed on 8/1/2024. 8/1.
CD
Monday.
has been called for. What's up? Heard, Mr. Your good name?
M. Ahmed.
Learned counsel for the applicants and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Hazu PS case number 710 2023 under section 326 307 34 IPC. This application under section 438 services prepared by 2 applicants, namely Rajeshwar Boisya and Usarani Boisya alias Usha Boisya, for grant of period paid. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Dixita Boisya on 7/12/2023. The learned counsel for the applicant submits that in connection with the same PS case number 710 of 2023, in connection with AB or BA?
BA.
BA number
4612.
4612, CD has already been called for,
26.
fixing the matter on 8. And accordingly, it is right that on that day, CD may be perused to dispose of the present bail application also, application also. Accordingly, it is provided that rest shall take this matter along with AB number so and so, no, along with BA number so and so, and on that day, CD will be perused to dispose of the present application also. Whether only CD was called for or the injury report,
Injury.
both.
Must.
Item 5.
Yes.
This application against the impugned judgment of order dated 5/10/2023 Lordship. Passed by the learned session judge Lordship Kachar Lordship. Allow the appeal Lordship and this satisfies the judgment order passed by the learned judicial magistrate Lordship Kachar Lordship. Lordship, facts is that Lordship. Accused Lordship. For an amount of rupees 4 lakhs from the petitioner Lordship. And he did not pay the said amount on repeated request Lordship. Then Lordship on 31, Lordship, then 15/1/2018 Lordship, a check was issued by the accused Lordship. The name of the complainant Lordship. Then the complainant deposited the said check before bank Lordship, and that check was dishonored Lordship. Accordingly, the Lordship, the petitioner filed the Lordship and complaint case under section 138 Lordship with the learned chief judicial magistrate Kachar Lordship. Lordship, Procedural of the Lordship, evidence and materials on the case record, Lordship, the learned chief judicial magistrate, Lordship, on conclusion, Lordship, convicted the accused Lordship for 2 years, simple imprisonment and a fine of rupees 6 lakhs, Lordship. And against that, judgment and order, Lordship,
On
the-
what ground judgment has been
Lordship, I
reversed?
kindly see page 27, Lordship,
20?
7, Lordship. From paragraph 11 of last line, Lordship. Page 27, including judgment, Lordship. And from paragraph 11, Lordship. it will be well.
Paragraph?
11, last, Lordship. From the deposition of PW1. Reported, Lordship. To judgment, Lordship. Last-
Paragraph?
Paragraph 11, Lordship, last, Lordship. From the deposition of PW. I got it, Lordship. It is clear that accused obtained a loan
Mm.
of rupees 4,50,000 on 2010-2011 from this from him through receipt detection and so on. The limitation period of recovery of the said debt was 3 years, Lordship. Now, Lordship, it is not a Lordship, a civil suit, Lordship, that a 3 years limitation is required, Lordship. The case is under 138, Lordship. And limitation period is 30 days, Lordship, after issuing of notice, Lordship, as per section 138, Lordship. Now, on that ground, Lordship, this judgment was judgment passed by the learned PGM, Lordship, was set aside, Lordship. Only to this ground, Lordship, that 3 years, the petitioner filed the petition after 3 years, Lordship. And section 19, 20.
Okay, okay. Heard, Mr. Your good name?
B. Malakar, Lordship.
Pardon?
B. Malakar.
B. Malakar, learned counsel for the petitioner. This. No, the correctness or otherwise of the judgment and order dated 5/10/2023 passed by the learned sessions as Kasar Silsor in criminal appeal number 6 of 2020 is challenged in this revision petition under section 401(397) of the Code of Criminal Procedure. It is to be noted here that by the interim judgment and order dated so and so, the learned additional session judge Kasar Silsor who passed the order? Additional session judge or session judge?
Additional session judge, Lordship. PC.
But in the cause title, you have mentioned it that, as a session judge.
From Lordship.
Learned additional session judge Kasar Silsor has set aside the judgment and order dated 31/12/2019. 19 or 29?
Lordship.
19 or 29?
Which Lordship?
This date of judgment?
Lordship, 5/10/2023.
No, the judgment of the additional CJM.
CGM 31/12.
31?
12.
12
Yes, Lordship.
of which year?
19, Lordship.
19. But what you have written in the cause title?
Lordship, I am sorry, Lordship, I very mistake, Lordship. It's 19, Lordship. I may be allowed to correct it. Should be Lordship 19.
Passed by the learned additional chief judicial magistrate Kasar Silsor in CR within bracket NI case number 61 of 61.
Your Honor,
61 of 2018 under section 138 NI. Where is the petition and the documents placed on record? Let notice be issued returnable in 4 weeks. Step be taken by registered post and also by usual process upon the sole respondent within a week from today. Rest shall call for the record from the learned court below. List the matter after 4 weeks.
Item 6, Lordship, may I permit to correct this 19, Lordship?
No, there is procedure for. You have to file I.
Resolution 438 application ballot. Annexer, who is the affair ballot? There is a lady, Asha Kurmi, Allegation 376 and ballot. And 330 ballot. I am not named in the affair ballot. Not named in the affair, the co-accused already been given privilege of pre-arrest bail and except 3 ballot. Main accused 1 and 2 has already been arrested, my lord. And it is the alleged in the affair that because of the love affairs, my lord, with the accused number 1, my lord, with the daughter of the informant, my lord. My lord,
What
here
is this
my lord,
376 and
my lord, repeatedly committed, my lord.
pardon?
My lord, 376 and my lord. Well, I am not in the affair name. No, not in the FIR, although not in the my lord. Offense is very serious in nature, my lord. My lord, and our role is not ascertained from the FIR, my lord. My lord, from CD it will be revealed, my lord. And except 3 page 19, my lord. Not name in the FIR approved before this honorable court, my lord. And this honorable court pass an order giving the privilege of period bail interim, my lord. I have annexed page 19. CD is required, my lord. Well, of course, my lord. I'm a lady, my lord, Asha Kurmi, my lord. That, my lord, maybe participate in the investigation, cooperate with the police officer, make whatever they inquired us before given. And except 3 page 19 make a leave. I'm also not night in the affair. If it is not my FIR, my lord, how he is expensive he is chasing me like a cattleman. Even I'm a government worker, my then there are some materials. Well, let the city for this time, my lord, protect I'm an employee. There is no chance of responding.
So why you were apprehending against?
My lord. My lord, police every day, my lord, coming and starting searching of me, my lord. Because of that, I have to apprehend, my lord. My husband has been called, my lord, 2-3 occasions. Let the diary come, my lord. My lord, question of 370 does not rise. It at all, my lord, 313, my lord. 313 may come, my lord. That is why, my lord, ought to have been mentioned in the affair, my lord. In the name accused affair 1 and 2, they are both son, father and son. They arrested, madam. But only because of the previous gas, and there is a good relation with the accused number 1 and 2. That is why, madam. Let the diary come, my lord. I am not paying absolute bill, my lord. In the meantime, I will be protected, my lord. Let my statement may be recorded, my lord.
Okay, pardon me, sir.
Page 19 and except 3, my lord.
Your good name.
AKMC.
Learned counsel for the applicant and also heard Mr. B. Sarma, learned additional PP for the state respondent. Apprehending arrest in connection with Gorabanda PS case number 179 of 2023 under section 120B, 376N, 313 IPC. This application under section 438 services prepared by applicant Sajina Nesa, Saijan Nesa for grant of period space. The above noted case has been registered on the basis of one FIR lodged by one Manija Khatun on 22nd/11/2023. The essence of allegation made in the FIR dated 22/11/2023 is that her daughter, Simoti X, name hotel, aged 19 years, have affairs with Raqibul Islam of Unaikuri village. Who established physical relation with her daughter about 6 months back in their absence. And after 15 days of said physical relation, Raqibul Hussain again taken her daughter to the jungle of Unaikuri and established physical relation with her against her will by gagging her mouth with cloths. Then on 6/11/2023, her daughter complained about pain in her stomach, in her abdomen, and then she was taken to FRU at Borpeta Road. And after sonography, the doctor informed her that her daughter is pregnant of 5 months. And then on being asked, her daughter disclosed that Raqibul Hussain committed sexual intercourse with her. And thereafter, the matter was reported to Raqibul Hussain. But they refused to, but they denied the allegation and taken her daughter to the doctor for checkup. And accordingly, doctor provided 3 numbers of injection and 2 numbers of tablet to her. And thereafter on 10:30, thereafter at about 10:30 p.m. at night, they kept her daughter in her house. And thereafter, her daughter aborted her pregnancy. The learned counsel for the applicant submits that the applicant is where she has been working.
Is Office of the Malad Senior Medical Health Officer in charge, Nimua PHC.
In what capacity?
Page Asha, whatever, Asha. It is there, Malad, it's a 1 page.
The applicant has been serving as ASA worker in where?
Malad, there. Baksa
Nimua PHC of Baksa district. And her name is not there in the FIR, and she is no way involved with the offense alleged in the FIR. But she is being searched by police and apprehending arrest. She approached this court by filing the present petition. Mr. Hussain further submits that by the order dated 14/12/2023 in AB number 4189 of 2023, a coordinate bench of this court has already extended the privilege of periodic bail to one of the co-accused. One of the accused, namely Batasi Begum. and that the applicant is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, submits that at this CD may be called for. CD may be called for. Those to examine the role played by the applicant in the aforesaid offenses. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case area before this court on Sharma when?
My lord. 18th, my lord. 18th.
18th. And considering the submission of learned advocates of both sides, and also the nature and gravity of the offense, this court is inclined to extend interim protection to the applicant till receipt of the case diary. And accordingly, it is provided that in the event of arrest of the applicant in connection with Gorubanda PS case number so and so under section so and so, not Gorubanda, Govardhana PS case number so and so under section so and so, she shall be enlarged on interim period as bail on her executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. Therefore, privilege is, however, subject to the following three conditions. Last condition, she shall not leave the jurisdiction of CJM Baksa. CJM Baksa without prior permission.
Item number 7.
My lord, 438 application, my lord. FIR is at page 8, my lord. Rash and negligent driving, my lord, 279 IPC and 304 A, my lord. Both the sections are available.
Available. Whether this petition is maintainable.
My lord. Both are available, my lord.
Yes, my lord.
304.
No, whether this petition is maintainable.
Because, my lord, police is unduly harassing, my lord. That is why, my lord. I have said it in the-
This petition under section 438 CRPC is not maintainable.
My lord.
Both the offenses are bailable.
Available, my lord.
What to do? We'll dismiss it or
Right.
you want to withdraw it?
My lord, let us withdraw that. The direction, lordship.
What direction?
not
Bailable offense?
maintainable. Lordship, I withdraw, my lord.
Mr. D.K. Bakshi, learned counsel for the applicant, submits that he has the instruction to withdraw this application. Pair is accordingly allowed. This AB stands to dispose of on withdrawal.
Number 50.
Lordship, the learned counsel is on legs. Kindly pass over the matter for time being.
51.
Ma'am, please. Versus item 51 and 52, they are arising out of the same matter. 51 is, my lords, the mother, and 52 is the daughter, and the husband and the father of both the parties is already in custody. My lords, I am before my lords, after a transit, the protection was given to me by the Honorable Bombay High Court in terms of the order at page 63. My lord, may just see the order at page 63. That's where it starts, my lord, the effective, I'm sorry. The effective, am I audible, my lords?
Yes, page number?
Page number 63, my lords, the order starts. And page 64 is the operative part where I was given protection. My lords, may I see para 8. Page 64, para 8, my lords. My lord has it. This is an order passed by the Honorable Bombay High Court, my lord. My lord has para 8.
Yes.
It says prima facie, it appears that the genesis of the alleged offences in the commercial transaction between the parties. Since accused number 1 has been arrested, the applicants have a genuine apprehension of arrest. The applicants are women and are willing to appear before the investigating officer and cooperate with the investigation. Thereafter, my lords, the order was passed whereby I was directed to appear before the investigating officer on 28th of December at 10 o'clock, which I have done. And the investigating officer also called me again on 2nd of January. I have appeared and I'm right now in Guwahati waiting for the investigating officer to interrogate me. The long and short of the allegations are, my lords, the complaint, according to the complaint, there is some siphoning of money from one company to another company through shell companies. And he says the money has been siphoned off to another companies and I'm a 50% stakeholder, nothing has been given to me.
So
That's
where is the FIR?
My lords, the FIR starts at page, my lord, I'll just, 41, my lords. It starts at page 40.
45.
If I may just respectfully take my lords to page 59, just to give a texture of the allegation in the FIR. Page 59, my lords.
Yes.
Allow me to read just 3-4 paragraphs of the FIR, my lords. Para 20. It can be shown, my lord has it. It can be shown by the financial records of the company that the informant has only received amounts as a salary employee and has never received dividends and or profits of the said company, nor have received any perquisite advantages or control over the affairs of the company as a director would in ordinary course of business. The promised share of the revenue generated by the informant, 50%, has never been given to the informant or made available to the informant, and the funds were never retained in BWW, which is the company, but were siphoned off by the accused person to their shell companies or otherwise withdrawn or used to pay off their personal bills or payment to vendors under fabricated invoices. The informant was on the entirety fed the story that since we are on a bootstrap and the business of the company was capital intensive, we were not profitable yet. Well, it's the next para. The direct transfer from the said company, that is Brit and BWW, to the shell companies, including Vistar, is about 139 crores, and further the amounts transferred by raising fabricated bills, over invoicing, booking false expenses would be in the tune of rupees 30 to 40 crores. Thus, the informant's share to the defalcation by the accused person would be to the tune of 80 to 85 crores. Loss of profit and profits arising out of the assets acquired by the accused person is not accounted for. My lords, then para 24. To add insult to the injury, the accused person siphoned off money and squeezed out maximum amount by forcing the company BWW to take loan from the banks, NBFCs, to the tune of rupees 1.5 crores during February-March 2021, which were forthwith transferred to Vistar. The accused person deceived the informant that with the loan amount, business post-COVID would be revived and the share of the informant would be handed over to him on taking accounts. Para 25. Thereafter, the loans were not repaid as promised to the informant. The interest or loan was also not serviced. All money having been siphoned out, BWW was made almost bankrupt, insolvent. BWW was unable to pay bank loans, interest on bank loans, payment of staff salaries, payment of statutory dues, in particular GST, payment to creditors, vendors, and other liabilities. My lords, at the outset, if I may say, so far as the petitioner today before my lords are concerned, the mother and the daughter, they neither have any stakes in the company where the money has gone or in the company from where the money has gone. There is a list of shell company which is given in the complaint, except for one, my lords, which is not a shell company, which is a company run by me, by the mother, who's a very established and very respected person in the society, irrespective of the status of the husband. That's a company run by her. And none of the petitioners, either of the petitioners, have nothing to do in any of the companies, my lords. If I may just take my lords to the details of the shell companies, which are at page 50, my lords. may I request my lords to come to page 50?
Yes,
My lords, there para 9. These are the list of alleged shell companies through which the money has been siphoned off from one company to another. My lord has it.
yes,
So my lords, the company at Roman 6, which is gray matter, this is the only company which is a company owned by the petitioner in item 52, who's the mother, and it is all compliant, all laws compliant. I had given a loan to my husband of rupees 90 lakhs, out of which 20 has already been refunded. It was a post-COVID loan given by me to my husband to revive or help in reviving his company. So far as my status is concerned, my lords, if I may just take my lords to page 3 and 4 of my petition, they talk about what is my standing in the society independent of my husband. Page 3 and 4, my lords. My lord,
yes,
page 3, my lords, para 2. That the petitioner is a Master of Arts, Social Welfare from the Tata Institute of Social Science, Mumbai, began her career in the year 1986 as a labor welfare officer with Conproducts Limited, a then corporate joint operating in the field of consumer staples industry. Thereafter, in the year 1989, the petitioner was recruited as a faculty at the Tata Institute of Social Sciences, which is Asia's oldest institute for professional work, founded in the year 1936. Having served the institution for almost 17 years, the applicant joined the Future Group as their head, HR, at their office in Mumbai, wherein she undertook numerous initiatives for gender sensitization and sexual harassments, etc. In the year 2007, the petitioner, as a team leader at Future Ideas think tank, heading their qualitative research team, and undertook numerous initiatives in the field of corporate social responsibility. The petitioner has also worked with RAIN, which is Retail Employment Body for People with Special Abilities, where she immediately rose to heights and became a pioneer, employing people with autism and visual impairment. The petitioner is also a content writer, having written extensively on the social issues that have been extensively absorbed by Star Plus and Star Parwa as part of their serials. The petitioner has been featured on the official YouTube channel of Star Plus on numerous occasions, where she had helped develop understanding the evolving middle class of India and intersection with women's identity. She's also an author of the book. So, my lord, she, in her own right, holds a position in the society independent of the husband. So, Grey Matter is the only company in the entire list of companies which is given in the complaint, which is her company, and from where some money has been transferred to the company of her husband, which is clearly accounted for. I have disclosed it in the income tax return. It is, and I am regularly assessed to income tax, and part of it has even come back to me. 20 lakhs, I think 20 lakhs has 20 lakh has already come back to me out of the loan which I had given to my husband. So that is the only connection that I have with any of the companies which are allegedly involved today. And my lords, it is clearly a commercial dispute between a person who is holding 50% stakes in the company. And my lords, I'm also the husband, not me. My husband was given a notice under Section 8 of the IBC for recovery of some amount of money, which was replied by him. If I may just trouble my lords with some part of the reply, which will clearly reflect that it was a commercial dispute, and the amount, it was only that they could not arrive at a particular amount, and it's only for that reason that I'm being exposed to all this. And I have nothing to do with any of the companies, my lords. My lords, may just come to page 112. That's a part of my reply, the reply which was issued by my husband, by the other company, with Star. Yes. Yes, ma'am. Notice was issued to me under Section 8, to the company under Section 8 of the IBC. Yes. All these companies are, my lords, regularly assessed to income tax, and there is, yes, that's will be next. My lords, may come to page 112.
yes,
My lords, just a second, my lords. slightly slow on technology. 113, my lords, may come. This was a reply sent by my husband's company, lordships.
Mm.
Page 112, it starts with the heading says no amount is payable by Vistar to you. That is a reply to the complainant. And my lords, the next page, the first para. No amount is payable to by Vistar to you, my lord, has that part.
Mm.
Nonetheless, it starts with saying in the present case, there is no amount that is due and payable by Vistar to you. My lord's page 112, the second
Yes.
last paragraph. In the present case, there is no amount that is due and payable by Vistar to you because of the existence of the dispute in regard to the alleged amount of the debt. In fact, Vistar has counterclaims more than the alleged amount claimed against you inter alia towards various services like inbound and outbound call center, event management publication, IT software development, outlet management, sales, marketing, business, etc., etc. Then, my lords, in fact, as per Vistar accounts, my lords, there is one word I'm not able to understand. Account, statement and leisure account, leisure statement, you owe Vistar an amount of more than rupees 10 crores towards the services provided, including interest for delayed payments. Further, the claim is also towards the damages for breach of contract, increasing cost, etc. In fact, initially, Vistar was in progress of taking appropriate steps for recovery of its rightful dues by following an appropriate legal remedy. However, since Mr. Amit Tipnis, who is the complainant of BWW Global Private Limited, informed Vistar that they are facing some serious GST investigation from the Goods and Services Tax Department and that their bank accounts have been restricted, frozen, therefore they will not be able to pay the sums to Vistar towards his dues for the services for the time being, and they had requested to defer the recovery of the said dues. Now, Amit Tipnis is the complainant, my lord. So this was the this is my response to his notice. Then, yes, my lords. Then it says further in your alleged notice you have claimed the interest amount. Then that, my lord, may just skip that. And then the next is now my lords may come to page 114, which is the last para. 3. We say, my lord has it. We say that you have not set out the true and correct facts of the matter. The relevant facts relating to the case are briefly stated as under. Then, my lords, this is what I had to say about the outstanding dues. And then in the same para, my lords, subpara Roman 6, as stated in the earlier paras. My lord has Roman 6. As stated in the earlier paras, Vistar initially did not initiate any recovery proceeding towards BWW Global Private Limited towards its service dues on personal request of Mr. Amit Tipnis to defer the recovery of the said dues. However, in December 2020, when Vistar themselves suffered a hit by some GST issues for which they needed to clear some more GST liabilities urgently, later on during May 2020, Vistar won an old service tax. My lords, may skip that. So therefore, my lords may just see that this was the nature of dispute between the parties. Yes, and this company, which is BWW, is also in voluntary liquidation, which is pending.
So, Madam, pursuant to the order of the Mumbai High Court,
My lord.
you have appeared before the IO
My lords,
on 2 occasions.
my lords. One
First-
occasion I appeared, my lords, I was interrogated.
Yes.
Second occasion I was called on second.
Yeah.
I am here. I am in Guwahati in the hotel, but the IO has not approached me till now. Okay, my lord. My instructions are that I appear, yes, before the IO.
So, where is the apprehension of arrest?
My lords, if I wasn't protected by the Bombay High Court,
Mm.
my husband is already in custody, my lords.
Pardon?
My husband is already in custody.
Mm.
And
No,
if
in this application.
My lords, if I wasn't given protection by the Bombay High Court
Mm.
and given time and liberty to approach my lords
Mm.
and seek bail,
Mm.
then my lords, there is a strong apprehension of arrest because my husband is already, and I'm an FIR named accused.
Yes, Mr. Fukan?
My lord, here we have find, my lord, since 2007 to 2011, there is siphon of money about, my lord, the 139 crores. And moreover, what you have seen, my lord, the present petitioners along with the daughter, my lord, Monisika Sachin, they are named FIR. And your lordship may come to a page 47, para 3 and 4, your lordship. We, my lord, to begin with the accused person number 1, Sachin Adhikari, was known to the mother of the informant and share a good family relation with his family in the year of 2001. Sachin Adhikari approached the informant and was insistent that the informant join his company, that is BRIT, wherein he was holding the post of a CEO at the point of time, though the BRIT was an establishment and well-known name in the field of the education and entrepreneurship, and it was struggling to achieve the phenomenal success. The informant resigned from his job and joined a BRIT under the guidance of Mr. Sachin Adhikari and his wife Tejaswani Adhikari, the present petitioners. The informant was assured that as the business grew, he would be reaping profit over the year, and the informant refused to extend phase of the shared relationships of the mentor, mentee, and Adhikaris, and owing the fiduciary relationship between them and Adhikaris were having an upper-handed and full control of finance of the company. While the Sachin Adhikari service in his official capacity and BRIT ended of 2011, then the said Sachin Adhikari resigned from the BRIT in or about November 2011 and worked in the employ of a Monavia company at the United States of America up until 2014, that is for about 2 years. Since by 2011, the informant had grown phenomenally in the company and was the best performer. Thereat, the informant was offered to take up a directorship of the company. It is pertinent to note that despite not being a part of the BRIT of the over a period of 2 years, the Sachin Adhikari and Tejaswani Adhikari, the present petitioner, retained control over BRIT and shadow a promoters thereof. The Adhikari and the Sashikant Tej continued to be an active part of the business and in fact of the mastermind of the financial affair of the company since the inception of the throughout the course of the transaction of the state company. My lord, here we have seen, my lord, after going through the FIR, it is a family modus operandi, and moreover the FIR which was they have annexed, there are as many as 42 annexes, my lord, that has not been annexed in the state petitions, my lord. So, my lord, it is very much difficult to assert in the main relevance portions has been not annexed in the state petitions, my lord. And my lord, the FIR is not completed because the annexer is there, that has not been annexed. So, my lord, at this stage, may I pray, my lord, since it is an economic offense, and Supreme Court also, your lordship may very much knows in various cases, in P. Chidambaram cases, my lord, that is reported on, my lord, 2019, in paragraph 83. It is clearly says, my lord, the grant of anticipatory bail at the stage of investigation may be frustrated. The investigating agency to interrogating the accused and in collecting the useful information and also the materials which might have been concealed. Success in such interrogations would elude if the accused knows that he is protected by the order of the court. Grant of anticipatory bail, particularly in an economic offense, would definitely hamper the effective of investigations. Having regard the material said to have been collected by the respondents, so and so, and considering the stage of the investigation, we are of the view that it is not a fit case to grant anticipatory bail. And moreover, your lordship in Amit Kumar case and Nimagadda clearly say that, my lord, the economic offense is treated to be in class apart. It should not be treated as like in my general offenses. So it's need to be looked in visit, my lord, the said offense in different way, not in general offense, my lord. At this stage, may I pray, my lord, the case diary may be called for, my lord. Everything will be revealed. What is there in the case diary? Because the FIR is, my lord, the annexer is not annexed yet. It is not ascertained the enter, my lord, the prima facie of the case, my lord. So may I pray, my lord, case diary may be called for at this stage, no interim may be granted, my lord. And moreover, my lord, second occasion he was called for, my lord, the petitioner was called for. They said that, my lord, they are medically unfit, they did not appear before the IU, my lord. First occasion they have appeared, but the second occasion they shows, my lord, some medical illness, but they have not annexed any documents regarding the medical illness here in the state. So may I pray, my lord, case diary may be called for at this stage, no interim may be granted, and my learned senior friend is, my lord, appealing for the informant.
No, yes, okay, Mr. Fukan, you see, in the order, Mumbai High Court has Observe that it is a commercial dispute.
My lord, the Mumbai High Court, my lord, say commercial without producing any record, my lord. Because case diary is not available at that point. It is in transit bail, my lord. Because, my lord, everything will be revealed, my lord, when case diary is before lawsuit. So, on the basis of the submissions of the petitioner's counsels, my lord, the Mumbai High Court says, my lord, is commercial dispute. Let, my lord, records may come, whether it's commercial dispute or whatever it may be, it will be revealed from the case. So, may I pray, my lord, case diary may be called for, and my lord, till then, no interim.
Yes, Mr. President.
I have instructions to appear for the informant.
For the?
Informant.
Yes.
Now, my lord, my learned friend appearing for the petitioner is trying to emphasize that it is a commercial transaction. Lordship knows, my lord, to determine the criminality, what is necessary is the intention of the, my lord, accused. It is not the nature of transaction which is crucial in determining whether the case involves criminality. Now, what had happened, my lord? The observation of the Honorable Bombay High Court in para 8 of the order referred by the other side, that was in the context of, my lord, the transit bill. I don't think Honorable Bombay High Court had the occasion to go through the affair, my lord. Now, I'll just place one decision of the Supreme Court, what the Honorable Supreme Court had to say, my lord. Please have a look at para 10 and 11 on commercial nature of transaction. This is, my lord, 1999, 3 SCC 259. What is important is the intention. What inducement is given, not the nature of the transaction.
Where it is observed?
Para 10 and 11, I suppose, my.
Yes.
My lord is holding a. Yes, 1999, 3 SCC 259, para 10 and Rajesh Bajaj, my lord.
Yes.
10 and 11, 10, 11. Nice. Can I read it, madam?
Yes.
Yes. My lord, will kindly come to paragraph 11. Sorry, 10. It may be that facts narrated in the present complaint would well reveal a commercial transaction or a money transaction. But that is hardly a reason for holding that the offense of cheating would elude from such a transaction. In fact, many cheatings are committed in course of commercial and also money transactions. One of the illustrations set out under Section 415 of the Indian Penal Code is what you have noticed now. A intentionally deceived Z into belief that A means to repay any money that Z may lend to him and thereby dishonestly induces Z to lend him money. A not intending to repay A cheats. The crux of the postulate is the intention of the person who induces the victim of his representation and not the nature of the transaction, which would become decisive in discerning whether there was a commission of offense or not. Complainant has stated in the body of the complaint that he was induced to believe that the respondent would honor payment on receipt of invoices and that the complainant realized later on that the intention of the respondents were not clear. He also mentioned that respondent, anyway, it was in the facts of this case. So, my lord, there was clear inducement whereby I joined the complaint. Now, after joining, my lord, I could realize that these are the aspects which are going on. Now, my lord, my learned friend also made a submission that she has got nothing to do with the affairs of the company. She is a lady, therefore, how can she be implicated? Please come to page 50 of the petition, my lord. It's a part of the FIR. As my learned friend has pointed out, my lord, the FIR runs into 100 pages, more than 100 pages. Only a part of it has been annexed. Please come to page 50, my lord. Please come to Roman 6, small.
Yes.
These are the beneficiary sale companies who will receive the, my lord, the sum of money. Gray matter having registered office at so and so, so and so, so and so. Now Tejashwani, that is the present petitioner, my lord, accused number 2, is the wife of accused number 1. And my lord will kindly have a look at this sheet of transaction where the partnership firm had received 95 lakhs out of the siphon money. Kindly have a look, my lord. On 31/3/21 to Sachin Adhikari, 95 lakhs. And Sachin Adhikari and the present petitioner, my lord, they are the partners in the particular firm. This is gray matter. So therefore to say this is not in the know of the things is absolutely not correct. Merely because it is a commercial transaction, there is no warrant that it may not lead to any, it may not involve any criminality. And my lord, it's a matter which involves about siphoning of 139 crores. My lord, the most unfortunate part is, my lord, though he quitted that parent company in 2011 November, he retained the financial control. And I went on executing the works. I went on, I mean, now entire liability and all has been thrust upon me. If this is not cheating, if this is not criminality, what else is? Therefore, I respectfully submit, my lord, it's not a case where lordship would like to extend the benefit of pre-arrest bail at this stage, my lord.
May I respond, my lords? May I respond?
Yes.
Now, my lords, today the complainant is playing a victim, but the fact remains that all this started after IBC proceeding had started. When I made a counterclaim, I made a claim saying that, no, this is what you owe to me. That's when all this criminality has started, my lords. That's submission number 1. Second, my lords, he was holding 50% stakes in the company. He was a director. He was signing all the financial documents. If my lords feel so, I can even place them. He himself was signing all the documents. After 8-9 years, he wakes up and says that I was not aware of what was happening in the company. Now, my lords, to say that this, so far as this transaction is concerned, which my learned colleague is pointing out, at page 96 at my petition, I have disclosed it as a part of the leisure account. I have said that I have given 95 lakhs to the company where my husband had interest, and out of which the money has come back to me, my lord. This is a classic case of arms twisting, my lord, where I have nothing to do with the companies. My daughter had nothing to do with the companies. We've been implicated by way of this, and that also, unfortunately, machinery of a state is being used for this arms twisting, where the state probably would not have nothing to do. All the companies are registered in Bombay. Complainant stays in Bombay. I stay in Bombay. And there is nothing at all to be done. There is one small office, which was also only for the GST compliances, which was started in Guwahati, which had nothing to do. And the ground which is taken in the FIR to give Guwahati jurisdiction is that there were seminars conducted. 5-6 seminars were conducted in Guwahati. So therefore, let's not get into that, my lords. There I have my remedy. I'll avail that today. And my lord, my friend is talking about intention. I can understand if I'm asking my lords to acquit me. I'm not asking for acquittal today. I'm only asking for an anticipatory bail, my lords. Why is it that my custodial interrogation is required? Let my friends at least point out 95 lakh rupees I paid to a company. That's a part of the document. I'm not denying it. Part of it has come back to me. I'm not denying it. That's the only company with which I have anything to do. It's very easy, my lords, for the complainant to say that I'm the mastermind, etc., etc. Let him at least give the evidence that I'm a mastermind.
Let the city come, we will see.
My lords may do that. My lords may just protect me in the meantime. My lords may call for the CD. I have no difficulty. My lords, because my protection ends on 8th, on Monday. My lords may protect me, and
so on Monday we will fix it.
My lord, yes, my lord, I will call the case in meantime, my lord. On Monday, my lord, on 9th, my lord, we'll produce the case.
On 8, because on 8 their term will over. There's a okay, Hart Miss, your good name, please.
my lords, I'm Sonia Mathur.
Learned counsel for the applicant, and also Hart Mr.
I
N.
have
Kokon,
difficulty on
learned
but
PP for the state respondent, and Mr. Ken Soduri, learned senior counsel assisted by Mr. Learned counsel for the informant. Apprehending arrest in connection with Patasel number PS case number 220 of 2023 under section 120B 406 409 419 420 467 468 471 477A 506/34 IPC. This application under section 438 is prepared by applicant Tejaswini Sachin Adhikari for grant of periodic bail. The above noted case has been registered on the basis of one FIR lost by one Amit Tipnis on. What is the date of the FIR? On 22/9/2023. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that the learned PP shall produce the case area before this court on Monday.
Would my lord would my lord consider recording that she's already appeared on 28th and now she's here? On second she was called, she's appeared yesterday, she's still here in the hotel in Guwahati. Both the petitioners.
Okay, all right.
And one daughter who's not here is COVID positive, and that's the reason she's not now. The other two are here. I'm so grateful.
You want 52C?
I'm grateful.
52C.
53.
May it please your lordship. This is another woman before your lordship who is seeking periodic bail. Of course, here she is the victim. My lord, she is the owner of a company along with her other sons and husband. And my lord, we have given the particulars of that company and all. My lord, they were all residents of Impal. During this disturbance, they came to Guwahati and they have purchased a plot of land. Your lordship will find that sale deed at page 21.
Yes.
Now, if your lordship looks into that sale deed, your lordship will find that at page 21, the first party is Pradeep Kumar Das, second party is Sarita Devi Jain. And my lord, the total consideration is 1 crore 60 lakh only. And for this 1 crore 69 lakhs, my lord, I have paid all the money through bank. Those are mentioned in the bank statement. And even in the at page 27, I have given the schedule of the payment, my lord. These are not in cash, these are through bank transfers only. I am a bona fide purchaser of this land. My lord, page 27, your lordship will find the schedule.
No, you come to the FIR.
Yes, now, my lord, what has happened? My lord, the person from whom I have purchased, he came before this honorable court. My lord, your lordship will find the FIR at 82D.
Page number?
82D, my lord, capital D. My lord, the FIR is about 3 pages. The gist of the FIR is, my lord, the informant says that his grandfather had never given the land to the person who has sold the land to me. And in respect of this, my lord, same dispute, my lord, there is a civil suit pending and there is a criminal complaint also pending before the court for adjudication. And my lord, I being a bona fide purchaser, what I can do? I took a NOC from the concerned authority, GMC. I took the sale permission. I took all the necessary statutory protection or requirements which are to be taken before passing a land. Now what has happened? This person was granted previous bail. Then he went to appear in that case, this case today, which I am seeking. He took an interim bail. Then he went to appear before the IO as per the direction of this honorable court. And in another case, he has been arrested. So my apprehension is that my son has been called to along, because since the FIR is against me, I was not in home. My son was called. Son gave all the particulars and all, even identified all those persons and all. Now, being a woman, my lord, and in respect, there is already a title suit pending. Complaint is also pending in the criminal court, my lord. Then there is also an order granting interim bail in this case today to that Pradeep Das. My lord, I pray, my lord, till the production of the case diary, your lordship will kindly protect this woman because she is a bona fide purchaser of the land.
In the FIR, where your role is mentioned?
Yes, my lord, your lordship will find. Your lordship will find. Just a moment. FIR is all directed against the government official and all, but and against the land broker. And police has summoned me. I made a statement in my petition. Police has summoned me, and through my son has also asked me to appear. I can go and cooperate, and I can give all these documents to show that I am a bona fide purchaser of the land, madam. Your lordship, that's why I was drawing your lordship's attention to the sale deed.
Is there any allegation against you in the affair?
But an allegation, I don't see it directly against me, madam, in the FIR. But in the sale deed, my lord, my name appears, and I have given a statement, and my son has appeared yesterday also. And my lord, they were asked me to ask my son to identify the land broker. My son identified me. Now they have asked through my son to also calling me today. And I have a apprehension, my lord, being a lady, because this person, my lord, who was granted interim bail in this case, in the same case, my lord, he went and appeared, and he was arrested in another case also. That bail order is there, my lord. Your lordship will find at page 84. Same PS, my lord. Now, mutation has also been done in my favor. Possession of the land was also given to me. And now your lordship will see the condition. I have to now file a money suit against this land broker to recover that 1 crore 60 lakhs. And your lordship knows the possibility of recovery from this persons, my lord.
Mr. Sharma?
My lord, here is the main question is sale deed is fake, my lord. Sale deed is fake, my lord. Whatever done, mutation done only on the basis of the deed, sale deed. But when the sale deed is actually fake, my lord, then all the procedure is fake. Lordship, I pray for some time, my lord, to produce the case there, Monday or Tuesday, my lord.
Your lordship may kindly.
No, my lord, at this stage, no protection, my lord.
Your lordship may kindly look at page 41.
It is the my lord, land grabbing, my lord, some persons are already.
Some landowners have already been granted interim.
Arrested some of the arrested, my lord. It is under investigation, my lord. Monday or Tuesday, my lord.
Well, your lordship may kindly look at page 41.
Yes.
Well, this is the title suit filed by the informant's family, my lord. And here I am defendant number 2. Now your lordship will see the allegation here against the pleadings against me, my lord. The sale deed with the, if your lordship looks into this plane, your lordship will find that the sale deed which the first the seller has, that is fake, not mine. Mine one is genuine. For the money 1 crore 60 crores, I will not pay money against that. That was done before the sub-registrar's office. There, I have sought the GMC's no objection. I have seen that there was no mortgage or encumbrance against this. All these documents I have given, my lord. Your lordship will find the GMC NOC at page at the last page, my lord, page 88. This is GMDS NSC. Page 90 is the GMC permission, my lord. I don't know, my lord, from where my learned friend is saying that my sale deed at page 21 is fake, my lord.
No, my lord, from the FIR itself, my lord.
No, that is talking about the sale deed of with Pradip Das, not this sale deed. Because Pradip Das has said that he had a sale deed with the grandfather of the informant. That may be fake, my lord. I don't know about it. But in the record, my lord, there was nothing to show to me that I had knowledge that this land was not actually Pradip Das.
Heard Mr. B.D. Kaur, learned senior counsel assisted by Ms. So-and-so, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional VP for the state respondent. apprehending arrest in connection with volume of PS case number 0357 of 2023 under section 420, 406, 409, 468, 471, 34 IPC. This application under section 438 services prepared by applicant Srimati Sarita Devi Zain for grant of irrespect. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one
Dusmanto Medhi, page 82 F.
lodged by one Sri Dusmanto Medhi on what is the date?
8/12/2023.
On 8/12/2023. Having heard the submission of learned advocates of both sides, perusal of the case diary is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case diary before this court on
Tuesday, my lord.
Tuesday.
My lord.
Having considered the submission of learned advocates of both the parties, and also considering the facts and circumstances on the record, and the documents, and also the documents placed on record, this court is inclined to extend interim protection to the applicant till receipt of the case diary. And accordingly, it is provided that in the event of arrest of the applicant in connection with volume of PS case number so and so under section so and so, she shall be released on interim PRS bail on her executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition, she shall not leave the jurisdiction of CJM, Kamrup, and Guwahati without prior permission.
Deeply obliged, my lord.
My lord, let the matter be fixed on 11/1. Other case also fixed on 11/1, my lord. As per order, my lord. For the
11.
11th, my lord. 11th.
Sergeant number 8, matters for admission.
The petitioners before your lordship, case number 2 and 3, they are the relatives of the prime accused. And they are falsely implicated in this case. They have filed this for the petition for quashing of the proceeding. They are proceeding special prosecutor so and so, it is section 4. In respect of the petitioners, not against the prime accused.
The case was registered under section 4 also, or POXO also. Whether this kind of cases can be quashed.
But if there is some other documents there, you will see that there is no relation with them, your petitioner. So
There is no?
allegation. So there is allegation, but some other materials is there that they are also implicated. And moreover, they in the FIR mentioned the victim girl is 13 years, but in their total is there, they more than 18 years, victim girl. And the fact is that initially the victim girl was
that is a disputed question of fact. Whether dealing with the petition under section 482 CRPC, this court can go into that question.
That the abuse process of law is there because they are falsely implicated by their leadership. But some other documents there, the case is clear, your documents is there, both sides, their signatures also the informants. That initially victim girl was eloped with the accused number 1, Abul Hussain, who is the nephew of the petition number 1. And after 1 month, they roaming in several places, and finally after 1 month, they appeared in the house of the petitioner 1, and petitioner 1 intimated them. There is marriage also agreement, marriage agreement also there with the accused number 1, Abul Hussain, not the petitioner. Is the petition accused number 1 is the nephew of the petitioner number 1.
So where is the FIR?
The FIR, your lordship, page 12. Page 12, your lordship. Three accused persons, Abul Hussain, Abdul Jalil, and Kutub Ali. Accused number 2 and 3 before your lordship.
2 and 3?
Before your lordship, they are the petitioner in this case. Not the prime accused, your lordship. Page 13. May I read?
No, not necessary. Whether case diary was called for, LCR. At what stage the case is pending now? Whether charge has been framed?
It is fixed tomorrow for appearance at lower court.
Now you're on page 30. Next is page 30, your lordship. Here is it. There is a declaration of marriage between the accused number 1 and victim girl. They are eloped and the marriage is solemnized. Marriage agreement is there. Petitioners took initiative to the petitioners hand over the girl. After 1 month when they appeared, the victim along with the accused number 1 appeared in the house of the petitioner number 1. The maternal uncle of the prime accused number 1. Then petitioner 1 intimated the family members of the informant and handed over the girl. And this is that page 32, your lordship. This corresponds by 32. It is Zakir Hussain, the brother-in-law of the victim girl, handed over to him. With this, I have the honor the 520. My sister-in-law, Jasmine, eloped with second party. Second party is Abul Hussain, accused number 1. And in this regard, affair was lost. Today, in presence of below-mentioned guardians, both the parties handed over the marriage Jasmine Khatun from the custody of second party. After recovery of Jasmine Khatun, I being the first party, requested honor to it is intimated to the insults of police outpost. Missing complaint was there. They intimated the police. Also, your lordship.
And search sheet is submitted under section?
Charge sheet is under section, your lordship, 76. And charge sheet is page 20.
My lord, page 23. 120B, 366A, 342, 10,
4 of the Foxtrot.
and section 4 of September.
And we have another document, your lordship, page 34. It's your lordship, particular page 35. And reading the page 34, the informant signature also there. Page 34. Of the type copy. Particular page 35. The bottom serial number, guardian signature, Nurudnan is the informant. I have given this experience letter that 1 month ago from today, Jasmita Khatun, daughter so and so. Eloped with Abul Hussain, it is accused number 1, so and so. In this regard, today in presence of below-mentioned guardians of both sides, amicably settled the matter and myself, Zakir Hussain. It is the sister, the brother-in-law of the victim girl, so and so, has taken the custody of my sister-in-law, for taking her to my residence. Moreover, I have given an assurance that in Jasmine will not file any case, so and so. And after that, your lordship, they verbally assured the prisoner that after some days they will solemnize marriage, but they solemnize marriage with another person. page 36. Now the voter list they have annexed. After 2 months, the incident there means with another person. And the voter list I engaged Jasmina Khatun. It is shown as page 36. The age of the victim girl is shown as 21. In the affair says the 13 years. The 37, middle portion second is Jasmina Khatun. Dr. Mujibur Rahman, his age is 21. It's a voter list of 2021. An incident took place in 2017 last part, and that says the age is 13 years in the affair. But in the voter list says it is age of 21 years.
So, except voter list, do you have any other document to show the age of the victim girl?
I have thought that my learned friend appeared that the birth certificate can put it by.
Pardon?
My learned friend has appeared. My learned friend can put it the birth certificate, but I have not. How can I put it the birth certificate?
No, whether during investigation the IO has seized any birth certificate. Mr. Sharma?
Well, I am taking. In part 164 statement, it is 13 years.
No, that's all right. Any supporting document?
Well,
The marriage agreement, victim girl said in the 2017, 19 years. Page 30. Her signature of vaccine signature also there. Page 30 also. And the petitioners, they have to initiate to settle the matter. They have entered for the girl. And they have forced to investigate the case because some other reason is there. Because they are included also. Petition number 1 is a place politician, other who has a property chairman, property society. And his wife is a government chairman and that locality they are also implicated in this case. Page 30, victim girls declaration, her signatures also there. She said it in 2017, it is 19 years.
Yes, sir. What is your case?
First of all, my lord, whatever documents they have produced before this court, under 482, this cannot be looked into. This can be looked into during the time of trial, my lord. Number one. Number two, my lord, regarding the age of the victim, my lord, that also that question has to be raised before the trial court, not under 482. This is premature, my lord. And my lord, these are the main grounds, my lord. Their first ground is of compromise. With regard to that, my submission is that these are non-compatible sections, so that they cannot take that ground. And second,
Oh, no, well, where it is compromise?
they have produced these letters.
Which
Where-
letter?
My lord, first of all, my lord, they are saying that
Which letter?
page 32, my lord. Annexure 4, page 32, they have produced, my lord. Then again, page 34, annexure 5, they have produced, my lord. These are the two letters, my lord. Also, they have produced some declaration of marriage, my lord. These all will not work in their favor, my lord. These are non-compatible sections. My lord, Honorable Apex Court have said that even in case of when the sections are non-compatible, then the High Court can exercise its power under 482 and quash the proceedings, but not in all type of cases. In family matters, my lord, like 498A, etc., may be quashed. But these are heinous crimes. This cannot be quashed under 482 on the ground of compromise. And my lord, regarding the age, my lord, that is a matter of trial, my lord. They can always raise this ground regarding the age of the victim during the trial. Allegation is that the three accused persons the two petitioner and another, one more, have been continuously raping the girl in their house. That is the allegation, my lord. So if POXO doesn't come, my lord, other sections will be there, my lord. So that ground will also not help them, my lord. FIR says, my lord, the accused persons confined informant's daughter in the house of accused number 2 for 1 month. During that period, that is for 1 month, the accused numbers 1, 2, and 3 raped the informant's daughter, Jamina so and so, almost every night against her will. That is the allegation, madam. So, even if she is a major, even then some other sections will be there. If it is true. 376 is there, 266A. They will have to do it. These things will be, my lord, regarding the age also, the learned trial court will definitely consider during the stage of hearing on charge, my lord.
So, there is a three-judge bench judgment of Supreme Court in Gyan Singh versus State of Punjab. There, the principle of law has been summarized in paragraph number 57, where it is stated that heinous and serious offenses of mental depravity or offenses like murder, rape, dacoity, etc. cannot be fittingly quashed, even though the victim or victim's family and the offenders have settled the dispute. Such offenses are not private in nature and have serious impact on society.
I am not for the all, Quashing for the all lawyers. I am for the other papers. So they are not involved in this case. Though their affair is implicated, because the affair is not.
No, in the affair, there is allegation against all the three accused persons.
164 statement also there.
164 also. So we are dismissing the petition. Pardon?
I have certainly one judgment that is, if there is 160 also implicated, if there is some other material is there, then it should not be.
No, there is allegation against you in the FIR itself. And you have been solicited also. So prima facie case is there against you. You go and raise the issue so before the trial court, at the time of trial, and at the time of framing of search, and we are dismissing the petition. Not maintainable. Okay, get a separate. So we'll come back after.
Responded, your lordship.
Yes.
After condemnation of delay, your lordships, I have not been served with the revision petition, your lordships.
Actually, my lord, I am newly engaged counsel.
And
so
second
I'll-
point in this case, your lordships, this petition is not maintainable in view of section
No, let me
59 of
complete my
the
submission.
protection of minor.
Let me complete my submission.
Your lordship.
My lord, the petitioner preferred this revision petition against one impugned order passed by Lanet.
No, but you say in the act itself, so there is one provision
Appeal.
for filing appeal.
Yes.
So you have not availed that provision.
I am newly engaged counsel in this case, so today is my first day.
Mm.
So if he has not received a copy, I will serve, but what is my lord? Injustice has been done against the petitioners, my lord.
No, that's all right. There is provision in the act. You go and avail that provision.
Yes,
You file appeal before the session judge.
that's on that, my lord.
Yes. You withdraw this application, you go and approach.
Fine.
We will
Section
file you
20.
liberty.
Yes.
Oh, we will give you the liberty.
Liberty may kindly be.
Hmm. Heard, Mr. Your good name?
K. Kolita.
A. Colita, learned counsel for the learned counsel for the petitioner, and also heard, Mr. Ananja, learned counsel for the private respondent. This application under section 401, read section 397 of the Code of Criminal Procedure is preferred by the petitioner. Preferred by 4 petitioners, namely Nareshwar Nath, Nirendra Sandon Nath, Nilima Devi, and Raghudev Nath. Challenging the order dated 30th/11/2019 passed by the learned Subdivisional Judicial Magistrate S. Gwalpara in Miss Domestic Violence case number 204 of 2019. It is to be noted here that by the impugned order dated so and so, the learned court below has directed the petitioner to pay monthly maintenance at the rate of rupees 10,000 per month to the opposite party and rupees 3,000 and at the rate of rupees 3,000 to both the minor child of the opposite party, and further directed to make payment of rupees 3,000 per month as house rent, and also directed the petitioners to pay the opposite party an amount of rupees 50,000 as compensation. Mr. Zha, learned counsel for the sole respondent, submits that this petition is not maintainable in as much as there is one provision in the Domestic Violence Act itself, that is section 29, which provides for filing appeal before the before the session judge, and the said provision has not been complied with. And the said provision has not been complied with. Complied with, and as such, this petition may be dismissed. At this stage, the learned counsel for the applicant, petitioner submits that he may be allowed to withdraw this petition with liberty to approach the appropriate forum by filing appropriate application. Pair of Mr. Kolita, learned counsel for the petitioners, are accordingly allowed. This this petition is thus disposed of on withdrawal. However, liberty will remain with the petitioners to approach appropriate forum under appropriate provision of law.
Then
Met with your lordship. My lord, the fee is against the order. Lordship will find in order. Page lordship of 27. My lord, on the plea of guilty, this petitioner was convicted 5 years and also fined, my lord, along with other 5 years, my lord.
Where is the impugned order?
Lordship, page 27.
Relevant portion is page 29, my lord, last portion.
Yes, sir. My lord, two accused, my lord. One is convicted under section of theft, my lord. He was convicted under section 14A, B of the Foreigner Act, my lord.
So what is the name of the appellant?
Monir, my lord. 29, my lord, first para, my lord.
Hmm.
First para, my lord. Coming to the question of guilty plead by accused Monir, my lord.
Yes, my lord.
Hereafter, last portion, my lord, he was convicted. Rigorous imprisonment 5 years and
5
fine of
years.
10,000 in default so and so. Simple imprisonment for 6 months, set of period, my lord.
What is the offense? 381.
No, my lord.
And
In-
foreigners act also there, my lord.
No,
14th,
no, man. Against him, my lord, 14 A, B of Foreigner Act.
my
My
lord.
lord. Minimum punishment is 2 years and maximum 7 years, my lord.
Yes, court below has imposed 5 years.
5 years.
5 years, my lord.
So what wrong with the order?
My lord, the petitioner on the impression that he will be, my lord, less punishment, my lord.
No,
Right, but-
no, that plea cannot be taken. Because you know that the punishment is up to 7 years
Right,
and
right.
the court may impose 7
Super
years
high.
also.
That was, my lord.
Hmm?
I have taken some ground, my lord.
What are the grounds?
Last may kindly see on my petition, my lord. Page 5, my lord. More particularly B, C, and D, my lord. Read it, my lord.
Page number?
Page number 5 in my petition, my lord.
Yes.
My lord, I'd like to read B, my lord.
Hmm.
For that, the accused pleaded guilty on the understanding and exception, expectation of a very light and minimum punishment. And if he was made aware about the seriousness of the charge and period of imprisonment, he would not, would have
No,
taken the second, my
uh,
lord.
no, the appellant has counsel in the court below.
My lord,
Whether that was explained to him.
my lord, that's record will reveal, my lord.
Hmm?
So I pray for Lord, may call for the record, my lord.
Record was not called for.
The session case, my lord.
My lord, today is the first day.
What's
my
the
lord.
first day?
My lord, today is the first day, my lord.
My lord, I
Notice
have-
may also go, my lord. Notice will have to go, my lord. Notice, my lord. Respond number 2.
Heard Mr. Ziuddin, learned counsel for the appellant, and also heard Mr. P. Sharma, learned additional PP for the state respondent number 1.
1, my lord.
Who is this Pritam Kumar Hajam? He is the informant.
Yes, my lord. Earlier he appeared by counsel, my lord, when my delay petition was
Condon.
condemned. Okay.
In this appeal, under section 374, read with 375B of the Code of Criminal Procedure, the appellant, namely Mohammad Manir, has put to challenge the judgment dated 4/11/2022 passed by the learned additional session judge number 2 Kamrup M Guwahati in session case number 131 of 2022.
Yes.
Full stop. It is to be noted here that by impugn judgment, the learned court below has convicted the appellant under section
14A within bracket,
under
my lord,
section
small b of Foreigner
14A
Act.
within bracket small b of Foreigner Act, and also under section
No, my lord.
No, only,
That section.
no, section 381 is there, IPC.
My lord,
That is not against the present appellant.
yes, my lord. Another
Achha.
one is not before this.
And sentence him to suffer rigorous imprisonment for 5 years and also to pay a fine of rupees 10,000 with default stipulation. Where is the memo of appeal and the grounds mentioned therein, and the documents placed on record, including the impugned judgment and order dated 4/11/2022. Admit. Para. Let notice be issued. Notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post and also by usual process upon respondent number 2 within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Sharma, learned additional PP, appears and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Presidential call for the record of session case number
131 of 2022, my lord.
Session case number 131 of 2022 from the learned court below. List the matter after 4 weeks.
I have filed an IA, my lord.
IA.
After receipt of LCR. I will be considered, my lord, after receipt of LCR.
IA criminal number 1194 of 2020.
Heard Mr. Ziuddin, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This interlocutory application under section 389 of the Code of Criminal Procedure is preferred by applicant Mohammed Mani for suspension of sentence and to release him on bail during the pendency of the appeal. It is to be noted here that the applicant has preferred an appeal being criminal appeal number so and so against the judgment and order dated 4/11/2022 passed by the learned additional session judge number 2 Kamrup M. Guwahati in session case number 131 of 2022, wherein the learned court below has convicted the appellant under section 14A within bracket small b of the Foreigners Act 1946 and sentenced him to suffer rigorous imprisonment for 5 years and also to pay a fine of rupees 10,000 with default stipulation. The appeal has already been admitted and notice has been issued to the respondents. And the record has already been called for. Interim pair of the petitioner will be considered after receiving the record from the learned court below.
Well,
List after 4 weeks.
Obliged.
Matter number 11.
It's a criminal revision petition for Jimma of the commercial vehicle, that is a truck, which is lying in the custody since more than 8 months. The last 3 occasions, a scan copy of the LCR was stolen.
Yes, Mr. Sarba?
My lord. It was charged matter.
Police report was called for. And scan copy was also called for. Scan copy received.
My lord.
Have you gone through the record?
Well,
Record has been received.
My lord. This is a charged matter.
Proceeded under section?
Your lordship, this is NDPS Act. NDPS, the accused person is already released on bail. Page
That is not the ground for releasing the vehicle in your
23,
custody.
lordship. Page 23 clearly reflects that it is a charged matter by the opinion of the court. In my opinion, it is expedient to allow the Jimma petition at this stage as the case is charged and the trial is pending. This is a charged matter, so further custodial of the Jimma of the commercial truck is not required, your lordship.
Where it is observed?
in the page 23, your lordship, 9-10-23, order of the court. There are fifth there are, in my opinion.
Yes, so what wrong with the order?
Your lordship, it was simply it was rejected, petition was rejected that it is required for further investigation, but it is already a search-sheeted matter. Whereas in the Supreme Court has clearly mentioned in the Sundarba Ambalal Desai case, where it should not be kept into custody without any such reason.
Whether that ratio will be applicable in the present case?
search-sheeted case,
Hmm?
he is already, it is his source of income, your lordship. And he is
Maybe.
already, he has to give a
Is
EMI.
there any provision in the NDPS Act for releasing the vehicle in the interim custody of the petitioner? What section 60 of the NDPS Act says?
Lordship.
Section 60 of NDPS Act? Have you gone through?
In the order itself, it was revealed that earlier parameter. From the perusal of the case record, it appears that the above registered number truck has been used in commission of the offense as well.
Hmm.
That's why it was rejected.
Which part of the order?
Page 23, my lord.
Hmm.
Hardwood side. 1, 2, 3 parameter.
Hmm.
From the perusal of the case record, it appears that the above registered number truck has been used in commission of the offense alleged.
Hmm. Yes.
Yes, Lordship. Now the owner of the
At what stage the case is pending?
case is I need to go through the record for this.
We'll go to the record. If you want time, we can adjourn the matter.
Okay, later we'll go into it.
After vacation then?
My lord. Lordship, before vacation, your lordship, it can be taken up.
Before vacation may not be possible. Lot of cases are there. Heard Mr. S.
Yes, Ahmed.
S.
So,
Ahmed,
Lordship, in
Lord
this case,
Counsel
the
for the.
driver was taken into the custody. The owner has applied for the same, your lordship.
Pardon?
The driver was taken into custody in this NDPS Act. The owner of the vehicle has filed for the DMAR. And it has been more than 8 months, your lordship. This is source of
But
income.
that's all right. Whether the act provides it.
But the Supreme
Is there any
Court-
provision in the
Supreme Court has
NDPS Act?
clearly mentioned that nothing, the lordship may find the Supreme Court observation that the honorable court derived the practice of indefinitely keeping seized items in the
Where?
in the Supreme Court judgment.
Which judgment?
Sundarbha Ambalal Desai versus.
Whether
Devadasa.
there is any mention about the
NDPS.
articles or the vehicle seized in connection with the NDPS Act?
That has not been mentioned, your lordship.
Then?
But it has been clearly mentioned that in no case should be investigating officer keep this particle. for
Have you
indefinite
gone through
period.
the section 60?
Yeah, I have gone through the lordship, but this is only income.
Whether it is provided in the act?
No lordship, but in case of his livelihood, your lordship, he is paying 87,000 per month, your lordship, EMI, 5,000 per loss. He has been applying
That's
for.
all right, but if the act does not provide it, then
But the accused
had it
person is
been in the
also-
case of IPC offenses, then the
that is,
position would
ma'am.
have been different.
The
And the
investigation-
trial court would have also considered your pair.
Investigation period is also
Hmm.
over, your lordship, forfeited matter. But she may kindly allow the.
Okay, on 19, you go through the record, thereafter submit it. If there is any other case law in respect of releasing vehicle, seized in connection with NDPS Act. Hmm. And also heard Mr. B. Sharma, learned additional PP for the state respondent. The learned counsel for the petitioner submits that the matter may be adjourned so as to enable him to go through the record. Scan copy of the record which has been received from the learned court below. There is accordingly allowed, list the matter on 19. 18. Okay, 18. 18.
Item 14 for bail hearing.
May I please, my lord? My lord, 439 application, my lord, today is 69 days behind the bar. And my lord, it was called for.
What is the offense?
Offense is, my lord, under section 326, 307. 307 does not come.
Or a CD receipt?
Case diary not received lordship today.
But today is third occasion, my lord, for case. And 69
But the offenses are
days-
serious, 326, 307.
My lord, three-
What is the punishment for 307? Life.
326 lordship, then investigation up to 90 days lordship. 307 also.
And my lord,
307, there is two parts.
first part, that is 60 days.
First part is 60 days, second part is 90 days.
My lord, here were, my lord, three accused persons were arrested, including the present petitioner. And except this petitioner, other two has, my lord, already granted bail by the district judge.
By the?
District judge, Durham.
After perusing case diary?
Case diary.
That's all right.
My lord, and today is third occasion for case diary and 69 days behind the bar, my lord.
Then why don't you approach the district session judge?
My lord, already the bail petition is pending before this honorable.
Yeah.
And city was called for because of that, my lord. And I have to withdraw this petition. Then I may be, I will, my lord, approve the district judge. And the bail petition is pending last 1 month, my lord, before this. I go. My lord, your lordship will find the FIR at page 13, my lord. My lord, during the Durga Puja, my lord, there were thousands of persons, my lord. And neither, my lord, the victim was known by the petitioner, nor he has any link with her, my lord. My lord, here may be, my lord, the ex-boyfriend of the victim, my lord. My lord, attack her and escape, my lord, along with his friends and all the persons, my lord, the present petitioner along with other persons were, my lord, under CCTV surveillance. And they were, my lord, cited. And therefore, my lord, they have to taken in, they were taken into custody. Kindly see the FIR, my lord, page 13. Thousands of persons were here, my lord. And they were all were, my lord, under CCTV surveillance.
Page number?
Page 13, 1-3.
Yes, after going through the FIR, can it be said that no offense is made out?
Offense is there, my lord.
Then?
I'm admitting, my lord.
Then,
But my lord, the present petitioner, whether he is involved or not, my lord, he neither.
that's
know
why
the
perusal
person.
of the case there is necessary.
My lord, third occasion, my lord,
My lord,
he
I am-
is not coming,
I
my
am
lord.
praying to the matter on, my lord, 10th of this month, lordship.
10th.
That we will take.
Okay, Mr. R.J. Barua, learned additional PP, submits that case diary has not been received. And press for granting him some more time. Here is allowed. Place the matter on 10th.
Item 15.
Obliging.
Honorable Lordship. A petitioner behind bar more than 67 days, my lord, as in today, my lord. FR is paid, my lord.
Yes, city receipt Borwa.
Case that is received.
Is there any material against him?
So the material is that, my lord, this for the victim lordship, he was suffering from some inborn lordship. Then, my lord, this accused person lordship, he is a, my lord, village so-called doctor lordship. So he
Selling
prescribed some medicine earlier. So, my lord, he did not get well. Thereafter, lordship, again, my lord, the victim was taken to him, lordship. Then he also gave some, my lord, medicine like vitamin and something, and also gave prescribed to, my lord, injection, lordship. After that, lordship, he died.
Some medicine is from the custody of the petitioner, my lord. That is, my lord, all the medicines are.
He is
not
the so-called doctor of the village, lordship.
He's selling medicine, my lord. 67 days behind bar.
What is the stage of investigation?
The stage of investigation otherwise sufficiently progressed, lordship. Statement of witnesses recorded and seizure has been made. Only
So
my
the PM was conducted?
Postmortem report also collected, lordship, but, my lord, the final opinion has not been mentioned in the postmortem report, lordship, because, my lord, this, the visa and all this, it was sent for chemical analysis report. So that report, my lord, not been able to collect by the IO, lordship. Because it is not ready, lordship, as we have been informed by the IO.
Seven days, my lord. Behind bar, my lord. Already see.
So whether further custodial detention is necessary in the
That part,
interaction?
lordship, I leave it to your lordship, because, my lord, I have found from the case that it was almost, my lord, the other part of the
Heard
investigation-
Mr. A.M. Matin. A. Ahmed,
Yeah.
learned counsel for the accused, and also heard Mr. But what you will do after releasing from jail? You will again start the
No, my lord, no,
practice.
my lord. And it
Yes.
definitely no, my lord.
Yes.
Any
Yes.
condition, my lord.
No,
Any
no, any
condition.
condition, that condition, lordship cannot impose, lordship, that you cannot sell medicine.
Lordship, he's always selling some medicines, my
Hmm?
lord. I like Acilog, my lord, like fever, my lord, and my lord, Calpol, Becnosol, Missy, Pan 40, like that, my lord. PS21, my lord, Caesar. Caesar medicine.
So how can you prescribe those medicine without any?
To my information, my lord, he has not issued any prescription, my lord.
Hmm?
And I have seen, lordship, other similar type of cases in earlier occasions also, lordship. There are so-called village doctors. They used to prescribe medicine even to the pregnant women also, lordship.
Hmm.
Any condition similar of it may not be completed second time. Sufficient punishment, 67 days.
And also heard Mr. R.J. Borwa, learned additional PP for the state respondent. This petition under section 439 services prepared by accused Shah Alam, who has been languishing in jail as in connection with support PS case number 225 of 2023 under section 419 304 IPC. It is to be noted here that above that case has been registered on the basis of an FIR lodged by one Faminda Barmon on 29/10/2023. The essence of allegation made in the FIR dated so and so is that that the nephew of the informant namely Nirananda Burman was suffering from fever and the sister-in-law of the informant taken him to the accused who is a fake doctor and prescribe some medicine to them on a medicine to his nephew and the and after consuming the same gave no positive result, for which he was again taken to the doctor Shah Alam, and then the accused administered saline and injection, and thereafter his nephew was returning home, and on the way he became unconscious and ill, and he was taken to the hospital, government hospital, where the doctors declared him brought dead. Mr. Mr. Ahmed, learned counsel for the applicant, the accused, submits that the accused was arrested on 30th-10-2023, and since then he has been languishing in jail as for last 67 days, and he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. Borua, learned additional PP, submits that investigation of that case has progressed sufficiently, and the PM report has also been collected, though the final opinion is pending for collection of viscera report. And considering the seriousness of the offense, Mr. Borua has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It is not in dispute that the accused has been languishing in jail since 30th-10-2023. The case diary indicates that the IOA has achieved substantial progress in the investigation of the case, and the case is pending for collection of the report, FSL report, in respect of the viscera of the deceased person. Having regards to the nature and gravity of the offense and the punishment prescribed for the same, as well as the progress of investigation, and also considering the period of detention, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the
Judicial
learned
magistrate first class. Judicial magistrate first class Bilasipara.
Subdivisional Judicial Magistrate Bilasipara. Case diary will return.
Item 16.
May I please, Your Lordship? The 439 application. Again, this is submitted.
Yes, Borough has they received,
Search is submitted.
search it. Under section 395.
395, Lordship.
What to do? You go and approach the trial court.
Yes, Lordship.
Oh, how many days you are behind the bar?
79 days here in this case, Lordship.
Heard, Mr. Your good name?
KK Henrik, Lordship.
Learned counsel for the accused and also heard Mr. RJ Borough, learned additional PP for the state respondent. This application under section 439 services prepared by accused Abdul Barik, who has been languishing in jail hazard in connection with Agia PS case number 8 of 2023 under section 395 IPC since 19/10/2023. The aforementioned case has been registered on the basis of one FIR lodged by one Ratan Saha on 18/1/2023. The essence of allegation made in the FIR dated so and so is that on 17/1/2023 at about 8:30 p.m. the driver and handyman of 407 truck bearing registration number AS25CC5529 of the informant was carrying 60 packets of betel nut from Athiabari, Dhukdhara to Hauli. And while the said truck reached Kalyanpur, Agia at about 10:20 p.m., then 10 miscreants who were coming in a four-wheeler vehicle restrained the truck wrongfully and took the driver and handyman to another place along with the betel nut loaded truck, showing them lethal weapons, and thereafter looted 60 packets of betel nut and also looted cash rupees 25,000 from the driver, and thereafter released them at Udlagaon under Nagarbera PS. The learned counsel for the accused submits that the accused, he was shown arrested in this case.
Yes, Lordship.
He was arrested in connection with some other cases.
Some other call for a PS case.
Whether bail was granted in that case?
In that case, bail was granted, Lordship.
The accused was arrested in connection with what is the number of that case?
PS case Gwalpar, PS case number 145/2023 under section 120P 399 400 and 402 of IPC read section 25(1)A of Arms
Arms
Act. Paragraph 6 in my application.
He was arrested in connection with Golpara PS case number 145 under section 120B 399 400 402 IPC dated section 25(1)A of the Arms Act, and he was enlarged on bail by the learned Sessions Judge Golpara, High Order dated 6/11/2023 in Miss case number 664 of 2023. And that he will cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. RJ Barua, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet, being search sheet number
114/2023 dated
114 of 2023 under section
395 dated 31/10.
31/10/2023. In view of the submission of learned advocates of both the parties, this court is inclined to dispose of this bail application by directing the accused to approach the learned court below by filing appropriate petition. In terms of above, this AB instance, no, BA instance dispose of.
Item number 17.
Please, your lordship. 439 application, lordship, petitioner was surrendered before the trial court on 27/10/2023. Is entitled there for about 70 days, lordship. Earlier, lordship, the petitioner approached before this honorable court, lordship, at page number 26. Non-bailable warrant issued, and that was recalled and pass a direction to appear before the trial court. Lordship, the portion will start from page number 27, lordship, paragraph number 8. And accordingly, Joe appeared on a date fixed, not within the.
When he appeared before the
Appeared
court
on
below?
27/10/2023, lordship.
27/10.
Lordship. And next.
He is behind the bar. Still, he is behind the bar.
Behind the bar, lordship. In this case, lordship, it's a old case, lordship. FIR is lordship will find FIR at page number 9, lordship.
So, under which provision search it was submitted?
Search it submitted 366 and 34, but subsequently charged claim under 366A and 376. But as per medical report, lordship, the doctor examined, lordship. As per medical report, lordship, she is measured. She is more than 20 years, below than more than 20 years.
Maybe.
And
Whether
her evidence already in charge sheet, lordship, total number of witnesses cited, 8 numbers of witnesses cited. Out of 8, lordship, victim examined, informant examined, and doctor also examined, lordship.
total how many witnesses examined?
Total, lordship, 5 witnesses examined.
5.
5, lordship.
So only IO and doctor remains.
But it's a old case, lordship, 2008 case, lordship.
Maybe.
Lordship, that is why, lordship, though this case is registered under 370, charge claim under 376, lordship, that is not established as per the deposition of the victim and the lordship, doctor, lordship. Lordship, I'll appear before the trial court, lordship. Any stringent condition may be imposed, lordship. Because, lordship,
No, madam, you see, trial is at the last stage now. If we enlarge him on bail, then it will cause delay.
No, lordship, I'll appear each and every day, lordship. Any stringent condition may be provided, lordship. If I fail to appear before the trial court, it ended, that may be cancelled, that may be recorded in the order sheet, lordship. My intention to cooperate with the trial court, lordship.
On what basis you were submitting that offense under section 376 is not established?
Lordship, because I have gone through the deposition of the PW1, lordship. As per PW victim, lordship, it is as per her deposition of the, it's a long cross, lordship. As per that, lordship, the 366A is not there, lordship, because in her Nikah Nama, it is written as her age was 20 years. And no documents regarding her age established, lordship. And thereafter, what happened, lordship? When she boarded in the vehicle, thereafter.
No, you have been distorting your submission.
Lordship.
Earlier, you have stated that no offense under section 376 is established. Now
Lordship,
you are.
medical report is there, lordship. Just after that, lordship, medical examine after getting her, lordship, she was with him about 1 month, 8 days, and just after recovered her, she was medically examined. As per medical examination, lordship, PW5 deposition, lordship, There is nothing. In his opinion, her age 20 years or above, there is no sign of any thing, lordship, and there is no sign of any recent injury on her private parts or her body, lordship.
But the thing is that her evidence in examination in SIF remain unrebutted in cross examination.
In cross, he has stated just after 3-4 months of the occurrence, she got married one person from Silsar, and she, at the time of adducing the evidence, she has a 10 years old daughter, lordship, in the year 2011. My lord, right now I'm not on merit, lordship. Lord, I'll cooperate with the trial court. Every date I'll appear before the court, lordship. That is why I approach before the honorable court, lordship, and I appear in pursuance of the direction of the honorable court, lordship. Kindly consider that part, lordship.
We would have, but in the meantime, almost all the witnesses have been examined, barring the IO.
IO and two other witnesses are also there, lordship, outside there, lordship. One Dilwaruddin and Safiuddin. Then IO, lordship. My lord, any stringent condition, lordship?
No, not in serious thing. We are disposing of, we are directing the court below to expedite the trial.
In the meantime, lordship. Lordship, in the any, because lordship.
Only IO and two witnesses are there.
Lordship, my humble prayer before your lordship. It's a 2008 matter. IO may be alive.
Maybe.
No,
But the
lordship,
offenses
I
are serious.
comply, lordship. I comply the order of this honorable court, lordship. Kindly consider that part, lordship.
No, that is not the ground for enlarging one by.
With any stringent condition, lordship.
No.
Any stringent condition, lordship.
Heard Miss S.K. Nargis, learned counsel for the petitioner, and also heard Mr. R.J. Barwa, learned additional PP for the state respondent. This application under section 439 certificate is prepared by accused Abul Hussain, who has been languishing in jail in connection with Murdazar PS case number 65 of 2008 under section 366 34 IPC. The above noted case has been registered on the.
My lord, whether the IO has been examined or not, that report may be called for. If examined, that this matter may be closed. If examined, that may be called for within a short period, if possible.
No, you can take it from this.
The up to date LCR may not receive because it's a before vacation, lords. Puja vacation, winter vacation, lords. If complete, then there will be no matter, lordship. If not complete, then lordship may.
No, we will direct the court below to expedite the trial day-to-day hearing and thereafter to dispose of the matter finally.
Otherwise, lordship, if
Because it is pending since the year 2008 because of your fault.
Lordship, that is not my fault.
A warrant of arrest was issued against you. You approached this court.
In that case, lordship,
Who is responsible for the delay?
lordship, I am ready to cooperate with the.
No, your antecedent is not like that.
Lordship, kindly call for the present.
No, not necessary.
Lordship, on the next date, lordship, I will satisfy your lordship.
No.
In that case, lord, this is not bar for completing the trial court the cases, lordship. In that case, lordship, the present status may be called for, lordship.
Not necessary. Status is already available before the court.
Earlier, lordship, he used to appear before the trial court, lordship. From 2021, he remained absent, lordship, without any extent. That is why, lordship, NPW was issued. That is why NBW issued an Lordship, then he approached before his honorable court, then he was directed to APR Lordship. And that is why lower court has murdered again took him into the custody Lordship.
Because case transferred from Nagaon to Hujai.
I have perused the case, mother scan copy Lordship. Earlier he appeared Lordship. Then suddenly Lordship, he refrained from himself from appearing before the trial.
On the basis of an FIR lodged by one Mohammad Amir Hussain on 9/5/2008. The essence of allegation made in the aforesaid FIR dated so and so is that on 9/5/2008 at about 6 a.m. his sister Srimati X was proceeding towards ME Madrasa for attending coaching classes, and then accused Abul Hussein kidnapped her in one vehicle. Upon the aforesaid FIR, the officer inserts Morazar PS has registered a case being Morazar PS case number 65 of 2008 under section 366/34 IPC and carried out the investigation which culminated in submission of charge sheet against the accused under section 366 IPC. Thereafter, the learned court below has framed charge against the accused under section 366, 376 IPC. The learned counsel for the accused submits that due to absence of accused before the learned court below, non-bailable warrant of arrest was issued against him, for which the accused has preferred one criminal petition being criminal petition number 947 of 2023. And by the order dated 11/9/2023, this court was placed to dispose of the aforementioned criminal petition by staying execution of the NBWA issued against the accused and further directed him to appear before the learned court below and to apply for regular bail. And accordingly, the accused appeared before the learned court below on 27/10/2023 and applied for regular bail, but the learned court below has dismissed the same and remanded the accused to jail azut. And since 27/10/2023, the accused has been languishing in jail azut. The learned counsel for the accused further submits that as many as 8 witnesses have been cited in the charge sheet, and out of the 8 witnesses, 5 witnesses have been examined, and there remains to examine only 2 witnesses and the IO only. IO only.
3 witnesses yet to be examined.
Yes. And that the accused will appear before the learned court below on each and every date, and he is ready to abide by any condition imposed by this court, and therefore it is contended to allow the petition. Whereas Mr. R.J. Borua, learned additional PP, submits that though during first part of the trial the accused appeared before the court, yet he defaulted since when?
2021.
Since 2021.
Because transferred from Nagaon to Hujai.
Since 2021. And having regards to the conduct and the seriousness of the offense, the learned additional PP has opposed in granting bail to the accused at this stage. Whereas, having heard the submission of learned advocates of both the parties, I carefully gone through the petition and the documents placed on record, and also perused the scanned copy of the record from the learned court below. It appears that the case was registered in the year 2008 and charge sheet was submitted
37/2008.
on 30/7/2008, and since then the case is pending before the learned court below. And it appears that the case is pending since long because of the fault of the accused. Further, it appears that though 8 witnesses have been cited in the charge sheet, 5 have already been examined. 5 witnesses have already been examined, and there remains to examine 3 witnesses only. Having regard to the antecedent of the accused, this court is left unconvinced in the submission of learned counsel for the accused that the accused will appear before the learned court below on each and every date. Further, having regard to the nature and gravity of the offense and the submission of learned counsel for the accused, as well as conduct of the both sides, as well as conduct of the accused, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused, and accordingly the petition is dismissed. However, the learned court below is directed to expedite that trial, and if necessary to take recourse to section 309 within bracket 1 CRPC without and to dispose of it at within earliest possible time without being influenced by any of the observation made herein above in terms of above this.
My lord,
Yes, that's disposal.
my lord, my only humble prayer before this honorable court lordship regarding his conduct, if lordship reflected in the order sheet, so that this may affect in the trial lordship.
Yes,
That
there is
language may be kindly, my humble prayer, that language may be kindly altered.
no, that is there in the record.
But lordship, I cooperate with the trial court earlier also. Lord, that is why lordship, that
No,
language
the
may-
record is a record.
that there, because the record is there lordship, but
Orders
if
are
it's
there
for-
that you remain absent.
But lordship, if it is from the high court, then it will affect the trial, or that is why lordship. Only that part lordship,
Okay, we'll see.
that may be altered lordship.
There is not there.
Okay. On the pair being made by Mr.
Yeah.
P. Hazarika, learned counsel for the applicant, list the matter on. Borwa?
Any day after your vacation.
24. On that day, a learned additional PP shall produce the case before this court. Till then, interim order dated 38/11/2023 shall continue.
Timing item 1 for motion.
May I please the option, I'm sorry, my lord, I could not appear first time. This is a case under 482. Matter relates to 145 proceeding. I am the first party. I approach the court by making an application under 144 for initiating a proceeding. Then notice was issued, they appeared, position was declared in our favor. On consideration of the fact that my father purchased the land by registered sale in 1997. Then there was a revision preferred by them. Before the session court. And session court, my lord, setting aside the order, demanded back the matter to my lord district magistrate, additional district magistrate. And ultimately, my lord, matter was again reconsidered and position was declared in our favor. Then there was another criminal revision prepared by the respondent before the learned session judge. It was transferred to additional session judge. and session judge, my lord, while setting aside the order, declared their entitled interest. Therefore, my lord, at this stage, my lord, only notice be issued. Because we have purchased the land, there was a report submitted by circle officer. Circle officer says we are in possession. Therefore, 145 proceeding, my lordship knows that only the factum of possession is to be dealt with by the court below. Title cannot be dealt with. So at this stage, notice may be issued, my lord.
Heard, Mr. Professor, learned counsel for the learned senior counsel assisted by Mr. So-and-so, learned counsel for the petitioner, and also heard Mr. Borwa. Are you appearing here?
No, we have not been made party.
What, you are not a party.
It is a prior complaint case, my lord.
Hmm.
If necessary, my lord.
This petition under section 482 service is prepared by the petitioners, namely Srimati Reena Sarkar, for passing the final order
Order is annexure G, my lord. At page 105, dated 9/3/2022.
Nine 2022.
Yes,
Challenging the correctness or otherwise of the order dated 9/3/2022 passed by the learned additional session judge within bracket FTC Lakhimpur in criminal revision petition number 4 within bracket 1 of 2019. It is to be noted here that by the impugned order dated so and so, the learned court below has set aside the order
dated, my lord, 21/9/2018, passed by learned ADM Lakhimpur. May I
order
please
dated 21/9/2018,
Yes.
by which the learned additional district magistrate has declared possession over a plot of land measuring 2 lessa What is this 2 lessa and thereafter 3 bigha 2 kotha 2 lessa?
Out of 3 bigha 2 kotha,
Out of 3 bigha 2 kotha and 2 lessa in favor of the petitioner. Peruse the petition and the documents placed on record, and also peruse the impugned judgment dated 9/6, dated 38/11 2012.
original order. Page 90.
No, the latest order is dated
Latest order is dated 9/3,
9/3
2022.
2022.
This is the impugned order.
Yes, 9/3 2022. Let notice be issued to the respondents. Returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. Call for the record from the learned court below. List the matter after 4 weeks.
Particular order may be suspended.
Which one?
Impugned order, 9/3/2022. Because they are trying to, on the stand of this, they are trying to, once again, they are trying to encroach upon the land.
Having regards to the submission of learned counsel for the petitioner and also having regards to the facts and circumstances on the record, It is, no, this court is inclined to stay the order dated 9/3/2022 passed by the learned additional sessions as FTC Lakhimpur till disposal of this petition.
I'm obliged. I'm glad.
Coming item 50, promotion.
The petitioners are mother and son in relation. Okay? The petitioner number 1 is the mother and the petitioner number 2 is the son, who is a student of class 10 and is going to appear in the ensuing SSLC examination, lordship, and is also a minor, lordship.
FR is at page number?
FR is at page number 15, your lordship. Annexure D, lordship. And it was lost after 2 days of the alleged incident, lordship. Can I go through it, lordship?
Let the city come.
Lordship, my humble submission with regard to the petitioner number 2, lordship. His exam is near, lordship.
When?
His exam is from 16th of February, lordship.
16th of February. There are
He's
days.
a minor, lordship.
No, before that, we'll produce the case there.
When?
Lordship, if possible next week, lordship. That must, lordship.
Pardon?
If possible next week, lordship. That must.
Yes, next week.
On 11 month.
11? Okay, 11.
Item number 18.
My pleasure, lordship, my lord. This is succeeded case, my lord. Petitioner is behind the bar, my lord, for 169 days, my lord. After filing the charge sheet, the petitioner was approached before the learned trial court below, my lord. Can you see the
Let the
last
record
page,
come.
my lord?
Let the
Last-
record
last
come
page.
from the court below. Record and city. Registry shall call for the record and city from the court of learned, where it is pending.
Additional
CGM Borpeta,
Borpeta.
additional CGM Borpeta,
Borpeta.
fixing the matter on
Before vacation, my lord.
20.
Before vacation, my lord. 3 accused are absconding, my lord. Therefore, case is not committed, my lord. Case is pending for production of accused. There are 11 accused, my lord. There, my lord. 3 are absconder and
Boro, scan
Seven
copy
are
has
accused.
already been called for. It has not been received.
So the reminder may be so.
here absconder accused person is not appearing in the trial proceeding, my lord. Therefore, he is languishing in the jail, my lord.
We'll see the record.
Kindly see the last page, my lord.
Which one?
Minute, my lord. Last page, my lord, of this petition. Rejection order of the petitioner.
No, on that basis, we cannot consider the petition.
If
Let the
objection
record come, we will see. If there is no material against you, definitely we will protect you.
on 11 will.
Possible.
Many cases, Lordship, on 18th.
Then 19.
19. Okay. Rest is the lesser reminder to the learned court below for transmitting the case record and the case diary of PRC case number 2306 of 2023, arising out of customer appeals case number 23 of 2023.
Item 19.
They appeal the motion. 439 application manner 44 days behind the bar. Petitioner 1 and 2 are manner father and son manner.
Is it a surcited case?
No manner.
Borua, what is this? Order dated 15/12/2023. Scan copy of the record. Acha. Case diary has not been received.
No, we have received the case diary.
Received.
Investigation is pending.
Pardon?
Investigation is pending.
So today morning we have dealt with another petition
Yes.
of this accused.
430 that is.
Acha. When the case diary was there, we have called for the case diary.
Where is the manner?
When?
Your lordship fixed on 18 manner.
18. So you have not pointed out about this petition
My lord, since it
that
is,
the case diary has already been called for here.
no, my lord, my learned friend at that time pointed out, my lord, case diary received. But since it is a 438, not name accused, coordinate bench of this honorable court passed the interim protection that I have mentioned while submitting, and on the basis of the coordinate.
No, we have granted an anticipatory bail to one Asa Korni.
Asha Kaur, my lord. And
So we could have disposed of the bail application finally after perusing the case diary.
my lord, since the statement of the Asha Kurmi was not taken, she has been chasing my lord every day, including her husband. That is, in the
No,
morning. I
is it
mentioned-
necessary that in case of granting anticipatory bail, her statement has to be recorded by the police?
My lord,
Is it the requirement of law?
well, 161 statement or 162 statement, my lord, will help the investigation process. That's how what I
No,
said.
you are not supposed to look after the investigation.
Well, that
He
is
is there to
that is
take care of it.
Well, since I am not in the affair, my lord, who accused another petitioner, this honorable coordinator granted bail, whose name is also not in the affair, my lord. I am a government employee, my lord.
Who is this Aizul Haq?
My lord,
Petitioner number 2?
my lord, is the father of the petition number 1.
Yes, Borwa, any material?
Yes, material is there against the accused number 1, Lordship. Regarding accused number 2, Lordship, what happened? The accused number 1 and the victim got they had some love affair, Lordship. Then she got pregnant, Lordship. Then it was, my lord, her my lord, diagnosis was done. Then it was detected that she is carrying a fetus of 5 months. Then, Lordship, it was informed to the my lord, parents of the my lord, this accused petitioner number 1, Lordship. They took the victim girl to somewhere in the my lord area, my lord. Then they, my lord,
They
some-
means who? The petitioner number
petitioner
2?
Number 2 and his wife, mother of the accused number 1, Lordship.
No. So